Okay. Hey, clap up, clap up. She mute herself. Yeah, make she unmute herself then talk.
Yes. Registrar.
Yes. To speak and
Registrar, call the case. Yes. Call case number 1 on the course list, please. If you can hear me, call case number 1 on the course list, please.
okay. Suit number NICN/PHC/7M/2024. Between 1, Amolola Roberts. 2, Samuel Nnadueba. 3, Mr. Asano Mohammed. 4, Mr. Femi Adisa. 5, Mr. Gbenikanu Koti. 5, Mr. Gbenikanu Koti. 6, Mr. Samson Omoregbe. 3, Mr. Marinus Nwachukwu. 8, Mr. Kokoroko Roland. 9, Mr. Ogunu K. Ibe. 10, Mr. Moses C. Osaya. 11, Mr. Brown Omubo. 12, Mr. Samson Sunday Babatunde. 13, Mr. Omoefe Emmanuel. 14, Mr. Oguhat. 15, Mr. Olumide Sodipo. 16, Mr. John Ndabos. 17, Mr. Goodluck Ikoti. 18, Mr. John Omolugo. 19, Mr. Obire Francis. 20, Mr. Moses Omagere. 21, Mr. Paul Chike. 22, Mr. Abel Chima. And 1, D2D Services Limited. 2, D2D Holdings Limited. 3, D2D Oil and Gas Services Limited. My Lord, parties absent.
Yes, any appearance? Council.
With profound humility, my lord.
Yes.
OG Ojo, my appearance is for the claimant respondent. My lord.
Yes.
May you please, my lord?
Yes.
My name is Daniel Kip.
Yes.
My lord, I humbly appeal for the applicants.
Yes.
With profound respect, my lord.
Yes.
I am M.O. Oludimu for the 14th garnishing.
Yes. Any other appearance? This is ruling of the court. This ruling concerns the motion on notice filed by the judgment debtor on the 19th day of June 2026, pursuant to Order 17, Rule 1 and 14, Sub 6, 7, and 8 of the National Industrial Code Civil Procedure Rules 2017, and Section 6 of the 1999 Constitution of the Federal Republic of Nigeria and inherent jurisdiction of this court, seeking principally an order discharging and or setting aside the garnishee order 9C earlier made by this court. The applicants predicated their application on several grounds, including pendency of the appellate proceeding in suit number NIC/OW/10/2015 and NICN/YEN/442/2016 before the Court of Appeal in appeal number CA/PH/165/2024 and issues relating to the priority of the garnishee proceeding. The motion is supported by a 13 paragraphs affidavit, an affidavit of urgency and written address. Summary of the applicant's written address in support of the motion to discharge the garnishee order 9C. Learner counsel for the applicants formulated a sole issue for determination, namely whether having regards to the facts and circumstances disclosed in the supporting affidavit, it will not be in the interest of justice and public policy for the courts to grant the application and discharge the garnishee order 9C made on the 19th day of March 2024. In arguing the sole issue, counsel submitted that the applicants had placed before the court exceptional and compelling circumstances warranting the exercise of the court's discretion in their favor. Counsel referred particularly to paragraphs 8 sub 1 to 5 of the affidavit in support of the motion, wherein it was deposed that the garnishee order 9C had remained in force for over 2 years, thereby restricting access to the applicant's bank accounts and preventing them from meeting their operational and financial obligations. According to counsel, the continued restriction of the applicant's account had rendered them unable to invest, service their obligations to clients and business partners, pay off their salaries, or effectively conduct their business activities. Counsel further submitted that the applicants employ over the 100 staff members whose salaries for March and April had remained unpaid, resulting in staff resignations and threats of industrial action. It was further contended that if the order 9C remained in force, the applicants face the real possibility of ceasing operations altogether. Counsel argued that the continued subsistence of the order 9C was not only detrimental to the applicants, but also injurious to their employees, the employees' families, business partners, clients, and members of the public who depend on the services provided by the applicants. It also submitted that the public policy mitigates against a situation where the enforcement process of the court will have the effects of driving a business concern into insolvency or extinction. Counsel maintained that the applicants had survived only by resorting to loans and credit facilities, but that such measures had become unsustainable, making judicial intervention necessary to avert irreparable damage. On the concept of public policy, counsel relied on the case of Total Nigeria PLC against Ajayi Citation Supply, where public policy was described as the policy of the law against sanctioning acts that are injurious to public welfare or the public good. Counsel also cited the case of Start Oil Nigeria Limited against Inducon Nigeria Limited and another citation supplied, Yatrim Energy Utrim against Instat AS and others, citation supplied, and Corn Oil PLC against Vital SA, citation also supplied, in support of the submissions that the court ought not to sanction a course of action that is contrary to public welfare and public good. Counsel further referred the court to the decision of the Court of Appeal in the case of Start Oil Nigeria PLC Supra, wherein reliance was placed on the Supreme Court decision in the case of Okonkwo against Okagwe, citation supplied, which defined public policy as the prevailing ideals necessary to secure the welfare of the community and held that conduct injurious to the public interest is contrary to public policy. Relying further on Salisu and others against Abubakar and others, citation supplied, wherein the Court of Appeal, citing the case of Okumu Oil Palm Limited against Okpami, citation supplied, emphasized that justice is a three-way traffic involving justice to the claimant, justice to the defendant, and justice to the society at large. Counsel argued that the court must balance the interests of the judgment creditor against the wider consequences of maintaining the garnishee order. It was contended that justice in this circumstance required consideration not only of the interests of judgment creditors, but also of the welfare of the applicant's employees, creditors, customers, and the public. On the strength of the foregoing submissions, counsel urged the court to resolve the sole issue in favor of the applicants and to discharge the garnishee order 19 made on the 19th day of March 2024. Summary of the judgment creditors' written address in opposition to the motion to discharge the garnishee order. In response, the judgment creditor filed a counter affidavit of 42 paragraphs and written address opposing the application. In the written address, learned counsel for the judgment creditors formulated two issues for determination, namely, one, whether there is merit in the application of the applicants to warrant the discharge of the garnishee order 9C granted on 19th day of March 2024, having regards to the evidence and facts placed before the court by the judgment creditors. And two, whether following the refusal of the applicant's motion dated the 19th day of June 2026, thereby remains any obstacle preventing the court from concluding the garnishee proceeding. Arguing on issue one, counsel submitted that the relief sought by the applicants is discretionary and that a party seeking the exercise of the court's discretion must place sufficient and credible materials before the court, citing the case of Iton against United Bank for Africa, PLC, citation supplied, wherein the principle governing the exercise of judicial discretion was emphasized. Counsel further argued that garnishee proceedings are sui generis and are governed by the provisions of the Sheriff and Civil Process Act, Cap 6 laws of the Federation of Nigeria 2004, and Order 51 of the National Industrial Court Civil Procedure Rules 2017. In support, counsel cited the case of Central Bank of Nigeria against Interstellar Communications Limited, citation provided, and the case of Central Bank of Nigeria against Ikpila and another citation also supplied. Counsel submitted that the applicant's affidavit disclosed no allegation of fraud, concealment of material facts, or misinformation in relation to the garnishee order 19, Rather, the entire application was predicated on the considerations of public policy. It was argued that a valid court order can only be set aside where there is proof of fraud, concealment of material facts, or misrepresentation. Otherwise, the proper remedy is an appeal. Reliance was placed on the case of Jeff and others against Eotom and others, citation provided. Counsel contended that the applicants misconceived the doctrine of public policy and improperly sought to invoke it in aid of their applications, referring to the case of Total Nigeria PLC against Ajayi, citation provided. Counsel submitted that public policy is concerned with protecting the public interest and preventing acts injurious to public welfare. It was argued that the applicants are a private limited liability company and not a public institution, and therefore cannot rely on public policy to defeat the enforcement of a valid judgment debt. Counsel further submitted that, assuming without considering that public policy was applicable, the circumstances of the case favored the judgment creditors rather than the applicants. According to counsel, the applicants have been indebted to the judgment creditors since the year 2012 and have consistently frustrated efforts to enforce the judgment through repeated litigation and appeals, which they failed to diligently prosecute. Counsel argued that justice and public policy require that judgment creditors be allowed to enjoy the fruits of their judgment. Counsel also challenged the evidential basis of the applicant's claim that they had survived through loans and credit facilities. It was argued that no documentary evidence was produced to establish the existence of such loans, the lenders involved, or the terms thereof. Reliance was placed on the case of Magaji against Ladu and other citation provided, wherein the Supreme Court held that a court cannot speculate in favor of a party who fails to place relevant and cogent facts before it. On the basis of the foregoing submissions, counsel urged the court to resolve issue 1 in favor of the judgment creditors and dismiss the application as lacking in merit and brought in bad faith. On the second issue, learned counsel submitted that there is no legal impediments preventing the courts from concluding the garnishee proceeding. Counsel urged the court to examine its record, particularly the proceedings of 23rd day of April 2024, and noted that an application had already been made for the garnishee order to be made absolute against the 3rd, 14th, and 19th garnishees. In support of the propositions that the courts may take judicial notice of its own records, counsel cited the case of Shans Jason Limited against Omega Air Limited, citation supplied. Counsel further argued that the court to discharge the remaining garnishees and make the garnishee order absolute against the garnishees against whom funds had been identified as reflected in paragraph 20 of the counter affidavit. Or in the alternative, counsel submitted that while the judgment creditors did not oppose the discharge of the garnishee order in principle, such discharge should be conditional upon the applicants deposing the entire judgment debt and accrued interest assessed as at June 2026 into the account of the chief registrar of the court, or furnishing a bank garnishee for the paid sum from Access Bank PLC or Stanbic IBTC Bank PLC within a period to be stipulated by the court. Counsel argued that such an arrangement will adequately protect the interests of all parties pending the final determination of the matter. In conclusion, learned counsel urged the court to dismiss the applicant's motion dated the 19th day of June 2026 for want of merit, and in the alternative, either direct the payment or security of the judgment sum within a specified period of time, or proceed to make garnishee order made on 19th day of March 2024 absolute. The applicants, in response or reply on points of law, subsequently filed a further affidavit of 13 paragraphs and a reply on points of law challenging the competence of the counter affidavit and contending that the said counter affidavit offended the provisions of the Oath Act and Section 115 of the Evidence Act 2011. A reply on points of law, learned counsel for the applicants contended that the arguments advanced by the judgment creditors in opposition to the motion were misconceived and unsupported by the applicable principles governing garnishee proceedings. counsel argued that the applicants had placed sufficient facts before the court, demonstrating exceptional circumstances warranting the discharge of the garnishee order in the interest of justice, equity, and public policy. It was submitted that the authorities relied upon by the judgment creditors, including JEB and others against EOTOM and others, citation supply, were inapplicable because the applicants were not seeking to set aside a final judgment, but merely requesting the court, in exercise of its discretionary jurisdiction, to discharge an interlocutory garnishee order whose continued existence had become oppressive, detrimental to the survival of the applicant's business. Having carefully considered the processes filed by the parties and the submissions of the learned counsel, the court is of the view that the threshold issue is whether the counter affidavit of the judgment creditor is incompetent and liable to be struck out, and whether the applicant is entitled to the relief sought in the circumstance of this case. Learned counsel for the applicants argued that paragraph 43 of the counter affidavit merely stated, I quote, that I depose this counter affidavit in good faith, unquote. Counsel submitted that the jurat failed to comply with section 13 of the Act, Cap 01, Laws of the Federation of Nigeria 2004, and the first schedule thereto. Reliance was placed on the cases of GT Bank PLC against Abiodun Citation Supply, Hamidu and another against Kaduna Electricity Distribution PLC and another. Citation also supplied. Also, Saving Loans PLC against Iwu and Nara. Citation also supplied. I have carefully examined the authorities cited. The law is settled that an affidavit must comply substantially with the provisions of the Odd Act. However, the courts have equally drawn a distinction between defects affecting the form of an affidavit and defects affecting the jurat itself. The court, in the case of Bijara and others against Governor of Kwara State and another, citation supplied, emphasized that any omission to include the words stated in that section will not, in the absence of any fundamental defect as to the substance, render the affidavit invalid, since the omissions of the word of renders the entire counter affidavit incompetent. The crucial consideration is whether the affidavit was sworn before a commissioner of and bears the requisite jurat. The paragraphs relied upon by the applicants forms part of the body of the affidavit and not the jurat itself. I therefore hold that the objection founded on section 13 of the Oath Acts lacks merit. A essential portion of the arguments advanced by the applicants is directed at the competence of the counter affidavit. The applicants contended that paragraphs 25, 26, 27, 32, 33, 35, 38, 39, and 40 of the counter affidavit offend section 115 sub 3 and 4 of the Evidence Act 2011 because the deponent allegedly failed to disclose the source of his information and belief. Section 115 sub 3 and 4 of the Evidence Act indeed requires a deponent who relies on information received from another person to disclose the source, circumstances, and particulars of such information. See the case of AG against Access Bank PLC citation supplied, and Ahmed against CBN citation also supplied. However, the law is equally settled that where only certain paragraphs offend section 115 of the Yeah. 27, 35, 38, and 39 are incompetent, being founded on undisclosed sources of information, speculation, hearsay, or matters for which the deponent failed to disclose the facts and circumstances, forming the basis of his belief. Accordingly, those paragraphs are liable to be struck out. However, paragraphs 25, 32, 33, and 40 substantially comply with the requirements of the law and are therefore competent and admissible, although the evidential value or weights to be attached to some of them shall be assessed in the light of the surrounding facts and circumstances of this case. The effect of striking out those paragraphs is that the material deposition relied upon by the judgment creditors in opposition to the applications have been substantially weakened. On whether the application should be granted in the circumstance of this case, the law is tried that where affidavit evidence is not effectively challenged, the court is entitled to act upon it. See the case of TV Extra Productions Limited against NUC and another citation supplied, SIM Corporation Engineering PLC Limited, PLC against IPCO, citation also supplied, and also the case of Smart against Ijo Kita and others, citation also supplied. Having struck out the material portions of the counter affidavit, I am left substantially with the affidavit evidence of the applicants. The applicants have the polls to facts showing that appellate proceedings touching on the judgment debts and enforcement processes are pending, and that the continuation of the garnishee proceeding may create a situation which could prejudice the determination of those proceedings. More so, by paragraph 6 of the affidavit in support of the motion, it is before the court that the second and third applicants, who are never judgment debtors or parties in the substantive suit, were joined as garnishee in the proceeding, and their accounts with the other garnishees were attached alongside those of the judgment debtors. While it is correct that a notice of appeal does not by itself operate as a stay of execution, the court retains an inherent jurisdiction to prevent its process from being used in a manner capable of occasioning injustice. See the case of the Bessel Saint Roland and another against Osiloye, citation supplied. National Industrial Court, by virtue of section 254, part C, sub 1, paragraph F of the Constitution of the Federal Republic of Nigeria, 1999, as altered, and section 7, sub 6 of the National Industrial Court Act 2006, is empowered to apply principles of equity and international best practice in labor and employment matters whenever the circumstances of the case so required. In the peculiar circumstances of this case, considering the facts that garnishee order 9C attaching monies belonging to the applicants was made on the 19th day of March 2024, and the instant suit adjourned sine die pending the determination of the appeal, which is still after 2 years yet to be determined, I am satisfied that the interest of justice will be better served by preserving the rest pending the conclusion of the relevant appellate process rather than allowing irreversible steps to be taken. The Supreme Court has consistently emphasized that the purpose of judicial discretion is to achieve substantial justice between the parties. See the case of BR Marine Services Limited against Union Bank of Nigeria PLC and another citations applied. Having regards to all these circumstances, I am persuaded that the applicant has placed sufficient material before this court to warrant the exercise of discretion in their favor. Since the court cannot make the order absolute in view of the pending appeal after 2 years of attachment, it is proper to discharge same in the circumstance of this case. Consequently, therefore, the motion succeeds and is hereby granted as follows. 1, the garnishee order 9C made by this court on the 19th day of March 2024 is hereby discharged. 2, all further steps to the said garnishee order 9C are set aside. 3, the garnishee proceedings are hereby struck out pending the determination of the appeals proceedings. Parties shall bear their respective costs. This ruling shall be the ruling of the court.
As the court pleases. My Lord, we thank the court very immensely for this well-considered ruling. God bless you, my Lord.
Yes, Registrar, call case number 2 on the court list, please.
Suit number NSCN/PHC/79/2025 between Mr. Felix Wodu and one Pastor Jonathan Tobin, acting MD/CEO. 2, Rivers State Microfinance Agency. My Lord, parties absent.
Yes, any appearance?
May it please your lordship.
Yes.
Yes, my lord.
Yes.
B.K. Mwagwe. I respectfully apply for the claimant.
Yes.
May it please your lordship.
Yes.
Precious Odalume.
Yes.
I humbly appear for the first and second defendants. My lord, with me is my learned friend, Raymond Okpara.
Yes.
We are grateful, your lordship.
This is ruling of the court. The claimant filed a complaint before this court, claiming against defendants jointly and severally as follows. A declaration that the suspension of the claimant for the no just cause by the second defendant through the instrumentality of the first defendant as an employee of the second defendant via a letter of suspension dated the 22nd day of October 2015 is null, void, witch hunt, unconstitutional, and abuse of the powers of the first defendant, the claimant having not committed any offense prior to his suspension. B, a declaration that the trade carried out by the claimant by the head of Human Resources, Mrs. Doris Onukuru, Harry Ekegebo, the Chief Security Officer, Mr. Precious Lorekipo, Oga, and 2 police officers on the 22nd day of October 2025 without any memo first served on him showing his suspension is illegal and unlawful. C, a declaration that the use of police officer, chief security officer, Mr. Precious, and head of Human Resources to threaten the claimants out of office, to force the claimant out of office like a common criminal when no committee or body had found him guilty in accordance with the provisions of Section 6 of the Rivers State Microfinance Agency, Human Resources Policy Manual, and Procedures, that is Handbook, revised copy 2016. D, a declaration that the claimant is entitled to continue his work at the establishment and the claimant has not done any work assigned to the claimant in bad faith. He carried out all legal and legitimate directives assigned to him by the different heads, including the MD/CEO, with obedience. E, an order of honorable court restraining the claimant as a staff of the second defendant. In the alternative, pay the claimant a lump sum for the remainder of his service years, which is remaining 12 years after work for 10 years already. F, an order of this court perpetually restraining the first defendant, his agents, previous, and from further harassing, threatening, and intimidating the claimant in the course of carrying out his legal and officially assigned duties and directives. G, an order of this court awarding special and general damages in the sum of 20 million naira against the defendants. Pursuant to the above foregoing, the claimant's applicant filed a motion on notice, which was brought pursuant to the inherent powers and jurisdiction of this court, praying whereof for the following. 1, an order granting the amendment of the claimant's originating processes and substitute same which includes claims, verifying affidavits, statement of material facts, and claim, witnesses' depositions, list of witnesses, list of documents to reflect the amended paragraphs in the manner as set out in the proposed amendment, annexed here to and marked as Exhibit WF. 2 was an ongoing prayers. In reaction, the first and second defendant respondents deposed to a counter affidavit dated the first day of April 2026, accompanied by a written address dated the same date. Counsel the claimant applicants did not accompany the said motion or notice with a written address. Submission of the learned first and second defendants counsel. The learned counsel to the first and second defendants formulated a sole issue for determination, to which whether the applicant has made a case for the grant of the order sought in this application, and if not, whether the applicants ought not to be refused. He submitted that although this honorable court is vested with discretionary powers under Order 26, Rule 1 of the Rules of this Court 2017 to permit amendment of processes, such discretion must be exercised judicially and judiciously and not as a matter of course. He submitted that amendment is only permissible where it is necessary for the purpose of determining the real questions in controversy between the parties, securing substantial justice, and effectually settling the issues in dispute. Counsel also submitted that amendments may properly be refused where it introduces a completely different case, causes injustice or prejudice the other party, or is nullified, or is inconsistent or useless, or amounts to an abuse of court process. Citing the case of Pola against Babatunde, citation supplied, Alstom SA and another against Saraki, citation also supplied. He submitted that applicant has failed to demonstrate the proposed amendment is bona fide, necessary, or incapable of occasioning prejudice to the respondents. He further argued that applicant fails to file a statement of facts alongside the complaint as mandatorily required by the rules of this court. Consequently, the originating process is fundamentally defective and incompetent. That a fundamentally defective originating process is void ab initio, confers no jurisdiction on the court, and cannot be cured by amendment. Citing the cases of Induka against Akunobi, Ashaka against Umachku, Akingbule against Nigerian Roman Woods Industries Limited, all citations supplied. He argued that since the originating process is incomplete, this honorable court lacked jurisdiction to entertain the present application for amendment. More so that since no valid statement of facts was originally filed, there is no existing process capable of amendment. He relied on the principle that one cannot place something on nothing and expect it to stand. Citing the case of McFoy against USC Limited, citation supplied, Okoso against Gomwork and others, citation also supplied. More so that granting the amendment will amount to making an order in vain, which courts are enjoined not to do so. Citing the case of IC Investment Company Limited against Fidelity Bank PLC, and also the case of Obo against NFL Limited, citations supplied. He submitted that applicants' originating application related to suspension from employment, whereas the proposed amendment seeks to introduce a fresh complaint challenging the applicant's summary dismissal. Particular reliance was placed on the proposed relief seeking a declaration that the summary dismissal of the claimant was premature, a punishment without proof of gross negligence, dereliction of duty, and failure of oversight, and same being unlawful, null, and void with no legal effect. That the proposed amendment fundamentally alters the nature and character of the suit and introduces a new course of action contrary to settled principles governing amendments of processes. Citing the cases of APC and others against PDP and others, citation supplied, that the amendments intended to overreach the opposing party or substantially change the nature of the case ought not to be granted. He submitted that the instant applications amount to an abuse of court process because it seeks to cure an incurable defect. It attempts to amend a non-existing process, and it seeks to overreach the respondent by presenting an entirely different case. He posited that the Honorable Court possesses inherent powers under Section 6(6) of the Constitution of Nigeria 1999 to prevent abuse of judicial process, citing the case of Obasanjo and another against Olubode and others, DKGO Motors Limited and another against Allied Signal Incorporation against and others, citation also supplied. He maintained that the application is frivolous, oppressive, and intended to reissue the judicial process, and argued finally that the originating process is incurably defective. No competent statement of facts exists capable of amendment. The proposed amendment introduces fresh course of action. Amendment cannot cure the jurisdictional defects, and the application constitutes an abuse of court process, citing the case of Effiong against Ebong, citation supplied, and urged the court to dismiss the application for amendments in its entirety and award substantial costs against the applicant. Claimant applicants reply on points of law. He argued that the counter affidavit dated the first day of April 2026 filed by the first and second defendant respondent is replete with arguments, legal submissions, and conclusions rather than facts as required by law. Specifically, paragraphs 5, A to H contain legal arguments and citations of rules of court, contrary to sections 115 of the Evidence Act 2011 as amended, which restricts affidavits to statement of facts. Showing that the proposed amendment of court process is submitted that the court is empowered to prioritize substantial justice over technicalities pursuant to Order 5, Rule 6, Sub 3 of the National Industrial Court Civil Procedure Rules 2017, which allows the courts to adopt fair and flexible procedures in the interest of justice, citing the case of Eze against Federal Republic of Nigeria, citation supplied. He argued further that the respondents are merely dwelling on procedural form rather than the substance of the suit, despite the fact that the complaint already contains headings titled Statement of Material Facts, which the amendment merely seeks to separate and regularize its compliance with the procedural requirements. He finally urged the court to strike out the offending paragraphs of the respondent counter affidavits for offending Section 115 of the Evidence Act as amended and grant the application seeking leave to amend and regularize the claimant's originating process in the interest of substantial justice. I have carefully considered the applications, evidence, counter affidavit submissions of the learned counsel and authorities cited therein, other auxiliary issues. This court is of the view that the following issue needs to be resolved as they are the thrust of action. Other ancillary issues may also be considered in the determination of this issue, to wit, whether the claimant's applicant has placed sufficient materials before this court to warrant the grants of leave to amend the originating process. Before proceeding to the substance, I shall first determine the objections raised by the claimant regarding the competence of the portions of the counter affidavit. On whether paragraphs of the counter affidavit offend Section 115 of the Evidence Act, the claimant argued that paragraphs 5, A to H of the counter affidavit contain legal arguments, conclusions, and citations contrary to sections 115 of the Evidence Act 2011. The law is settled that affidavit must contain facts and not arguments, legal conclusions, prayers, or extraneous matters. See the case, see section 11115 sub 2 of the Evidence Act as amended, and also the case of Bami against the state, citation supplied, Ajomale against Yaduat, number 2, citation supplied, and also the case of Nwanko against Ecumenical Development Cooperative Society, citations also provided. However, it is settled that where facts and legal conclusions are intertwined, the court is entitled to separate the competent portions from the incomplete portions and rely on the admissible aspect. See the case of Falo B against Falo B. Citation supply, Attorney General of the Federation against Attorney General of Abia States and others, citation also supplied. Having examined the impugned paragraphs, I find that although portions contain legal arguments and conclusions, some do not substantially affect the competence of the counter affidavit. This court shall therefore only rely on the factual portions relevant to the determination of this application. I now proceed to determine the substantive suit. On the law of amendment process, the law governing amendments of process is well settled. Courts are enjoined to lean in favor of amendments where such amendments will enable the courts to determine the real issues in controversy between the parties and where no justice incapable of compensation by cause will be occasion to the adverse party. Order 26, Rule 1 of the National Industrial Code Civil Procedure Rules 2017 vests this court with discretionary powers to permit amendments of processes at any stage of the proceedings. Similarly, Order 5, Rule 1 and Rule 6, Sub 3 of the National Industrial Code of Nigeria Civil Procedure Rules 2017 empowers the court to depart from the technicalities in deserving circumstances in the interest of substantial justice. The appellate courts have consistently held that amendments ought generally be granted unless application is malified, intended to overreach, introduces an entirely new and inconsistent course of action, or will occasion injustice to the opposing party. See the case of Nelsa and Team and Associates against Nigerian National Petroleum Corporation, citation supply, Adeleke against Akin Olugbade, citation supply, Onaja against Oboni, citation provided, and also the case of Mobile Producing Nigeria Unlimited against Monopoko, citation also supplied. The court emphasized that amendments should be freely granted where it will facilitate complete adjudication of disputes and where the adverse party can be compensated by cost. In the case of Skybank PLC against Akin Pelu citation supply, the apex court reiterated that procedural rules are handmaids of justice and not obstacles to it. On whether there exists a process capable of amendment, the background of the respondent's opposition is that the originating process is fundamentally defective for want of a valid statement of facts and therefore incapable of amendment. I have carefully examined the processes before the court. The complaints filed by the claimants clearly contains body of facts setting out the grievances of the claimants against the defendants, though the format adopted by the claimants may not have strictly complied with the ideal procedural arrangements contemplated under the rules of this court. The substance of the factual complaint is clearly discernible. The question, therefore, is whether such defects renders the entire actions incurably void and incapable of amendments. The answer is in the negative. The National Industrial Court is a specialized court established primarily to do substantial justice in labor and employment matters. By virtue of sections 12 of the National Industrial Court Act 2006, this court is enjoined to avoid undue regards to technicalities. Further, Order 5 Rule 6 of the National Industrial Court Procedure Rules expressly empowers the court to regulate procedure in a manner that ensures substantial justice. The Supreme Court has repeatedly cautioned against undue technicality capable of defeating substantive justice. See the case of Bello against Attorney General of Oyo State, citation supplied. Ungosu against Imo State Environmental Sanitation Authority, citation also provided. And the case of Nigeria Industrial Court against Musa, citation supplied. It is also settled that amendments may be granted to cure defects in originating processes cannot be described as non-existent. There is, therefore, the court's a complaint accompanied by facts disclosing the claimant's grievance against the defendants. At best, the alleged defects relates to procedural form and the presentation. This court cannot shut its eyes to the fact that labor adjudication must prioritize substance over technical rigidity. I therefore hold that there exists a competent substratum upon which amendments can validly be operative. On whether the proposed amendment introduces a new course of action, the respondents further contended that the amendment introduces a fresh course of action by incorporating allegations relating to summary dismissal, whereas the original actions challenge suspension. Again, I am unable to agree entirely with the learned counsel to the respondents. A course of action consists of the aggregate of facts which gives rise to a right to sue. See the case of Adekoya against Federal Housing Authority citation supplied. The proposed amendment arises from the same employment relationship, same transactions, same disciplinary measures, and same factual matrix already before the court. The fact that the disciplinary process allegedly progressed from suspension to dismissal does not automatically amount a completely separate and unrelated course of action. The courts have held that where subsequent events are connected to the original subject matter, amendments may properly be granted to bring all issues before the court for complete adjudication. See the case of Retmi against Magrigo, citation supplied, Erogebu against Okorodu, citation also supplied, and also the case of United Bank for Africa, PLC against Abdullahi, citation also supplied. In labor and employment matters principally, events occurring after commencement of suit but connected with the employment dispute may properly be incorporated by amendment in order to avoid multiplicity of actions. This court has occasion pronounced on this principle. In the case of Mr. Charles Ugo against registered trustees of Holy Family Society in suit number NICN/EN/16/2024, judgment delivered on the 24th day of January 2017, National Court of Nigeria reported, where the court held that amendment should be literally granted in employment disputes where it will facilitate complete resolution of all connected grievances. I therefore hold that the proposed amendment does not fundamentally alter the character of the suit in a manner that will overreach the respondent. On the issue of abuse of court process, the respondents argued that the applications constitute an abuse of court process. Abuse of court process connotes the improper use of judicial process to harass, irritate, or interfere with the administration of justice. See the case of Saraki against Kotoye, citation supply. I have carefully reviewed the circumstances of this case, and I am unable to find any material establishing malafide or abuse of court process on the part of the claimants. The applications appears directed towards bringing all issues relating to the employment dispute before the courts for effective adjudication that cannot, without more, amounts to abuse of process. Ultimately, this court is persuaded that the justice of this case demands that the amendments be allowed so that the real issue in controversy between the parties may be effectually and completely determined. The respondents have not shown any prejudice incapable of compensation by cost. Accordingly, this application succeeds. It's hereby orders as follows. 1, leave is granted to the claimant applicant to amend and substitute the originating processes, including the complaint, verifying affidavits, statement of facts, witness depositions on oath, list of witnesses, and list of documents in terms of the proposed amendments attached as Exhibit WF. 2, the amended processes shall be deemed properly filed and served upon payment of all prescribed fees within 7 days from today. 3, the defendants' respondents are granted 14 days thereafter within which to file consequential processes. 4, costs of 20,000 naira is awarded against the claimant applicant in favor of the first and second respondents for the amendment. Ruling is entered accordingly.
As the court pleases.
As the court
We are very
pleases.
grateful, my lord, for the judge.
I'm very grateful for that erudite ruling.
Let's register a date.
The 10th day of November, 2026. My Lord, the 10th day of November. 10th day of November, 2026.
Yes, date.
My Lord, the 10th day of November.
Okay. This matter is adjourned to the 10th day of November 2026 for commencement of hearing.
As the court pleases.
As the court pleases.
Stop, please.
Most grateful, Lord.
I'm grateful, Your Lordship.
Ladies and gentlemen, have a nice day.
Most grateful.
Okay.
Excuse me, ma'am. This is the registrar. I don't know. Hello, ma'am. Registrar, good day. Please, has the first ruling be taken by my lord?
You said?
The first ruling.
What did you say?
The one that was scheduled for 10 o'clock.
Robert for 10 o'clock. It was scheduled to
Registrar.
1.
Can you hear us?
I make a sound.
Not okay.
Maybe she's checking.
That's great. Can you hear us?
Hello, ma'am. Can you hear us? Hello.
It was. Hello?
Yeah, can I hear you? Did
Are
you
you
hear what I asked?
sorry?
Did you hear what I asked?
What did you ask?
My lord was to give 2 rulings today. The first
Yes.
this thing was scheduled by 10. When we came on,
Okay.
we saw that it was rescheduled to 1 p.m. That's Omolola Roberts. So I was asking whether my lord has taken that one.
No, both ruling are 12, not 1. It's 12. So he started with the Omolola Roberts. So we are done with that one.
Okay, thank you very much.
It's Omolola Roberts that he took first. So both rulings were scheduled for 12, not different timing.
Okay, thank you.
You're welcome, please.
In the bush.
Okay. I think it's time to leave the meeting. Oh, and this one is still on. Wait. I'm going to call CB. No, leave.